So, welcome to No Kings on the Hill with Dr. Hilal and Joe St. Clair, Esquire, formerly known as Patriots Corner. If this is your first time tuning in, please hit the follow or subscribe button, which are free. And then also, please hit that like and share buttons to invite some of your followers who you think might enjoy the show. Also, please check out our website, which is rolling across the little banner at the bottom of the screen there, and then where you can find all of our previous episodes. Also, we will monitor the chat and respond to comments that expand on the current subject or spark an intellectual debate. So please, that is a very big help make the show better by participating in it. Now, today we're going to deep dive into landmark cases the Supreme Court is set to tackle this 2025. Now, to start today, we're really going to just concentrate on the Voting Rights Act of 1965 case that was heard today. And then also, if we get through that one in time, we're also going to cover and break down the decisions for the case that was just approved to go move forward. It's called Little v. Hecox, which is dealing with the men and women's sports and the constitutionality of that law of states making a law against boys playing in women's sports, constitutional or unconstitutional. So we'll go over that if we get time to get to that one. And then maybe later on we'll do another episode because they just released the current schedule. So it'll start getting busy here with, at least as far as we go with oral hearings and everything. Now, obviously, it'll be January 1st next year before we actually start hearing decisions and stuff on these cases. But they're at least starting to get started with all the hearings and all that fun stuff. So we'll get into that. Also, please, again, like I said, hit that follow or subscribe button so you can follow our updates on any stuff we do on legal matters or anything like that on our next episodes. Now, like I said, the Supreme Court is reviewing Louisiana v. Calais now, which was first argued in March and centers on whether Louisiana's 2024 congressional map, which added a second majority black district, amounts to an unconstitutional racial gerrymandering. Now, the Supreme Court's conservative majority seems poised to significantly weaken Section 2 of the Voting Rights Act of 1965, which requires states to create majority-minority districts, a provision the left claims prevents the dilution of minority votes. Now, this part is I'm going to read directly from the amicus curiae from the court today, and then I'll read also a little bit from, this is all from the amicus curiae from the court's, the recall for today. Now, the reality is that Section 2's race-based redistricting mandate as implemented by Gingles is both unworkable and unconstitutional. That is why parties and amici have flooded the docket with a myriad of proposals for Gingles repairs, updates, and renovations that would make Frankenstein blush. But no amount of surgery can eliminate the constitutional defects inherent in a system that at the end of the day requires states to sort their citizens by race. This case should begin and end with the twin commands of the Equal Protection Clause that the government may never use race as a stereotype or negative, which is, I'm not going to read the citation, but it's in there. And then also, race-based redistricting under Section 2 is principally unconstitutional because it inherently resets on a racial stereotype that all voters of a particular race must, by virtue of their membership in their racial 3 class, think alike, share the same interests, and prefer the same political candidates. As Louisiana explained in LA Superior BR 20-21, that class-based stereotype is baked into Gingles itself, which focuses on the minority group, and each of the three preconditions that racial stereotype is squarely at odds with this court's precedent. At the heart of the Constitution's guarantee of equal protection, the court has said, lies that simple command that the government must treat citizens as individuals, not simply components of a racial class. This goes back to Miller v. Johnson, where it cleans up Gingles itself violates that simple command, and so too does each federal court and state that sets out to draw district lines with an express racial target in mind. And that goes to Allen 599 U.S. at 33 plurality opinion. Now, some topside amicus briefs try to downplay this problem, insisting that Gingles avoid stereotyping by requiring a Section 2 plaintiff to show that the minority group is politically cohesive. By that logic, requiring a consistently strong shared communal preference for candidates eliminates any stereotyped assumptions that voters who share a race or ethnicity automatically vote alike or share the same concerns or interests. Now, going to Brennan, that argument implies that the political cohesion requirement compels a Section 2 plaintiff to show that every single minority voter shares the same political preferences. That is not accurate, not even close. Apparently, according to another topside amicus brief, the most common presumption applied by lower courts is that political cohesion exists if more than 64% of the relevant voters typically support the same candidates. Now, going to Stephanopoulos brief 31, if that number is correct, that means up to 40% of the remaining minority population does not share the same preferences and interests. And yet, the Gingles framework carries on with its focus on the minority group and the minority's preferable candidate. So, I think I'm almost down to the bottom of reading it. I took the first and I didn't take the second part of the brief. I just took the first part of the brief. Yeah, I've just got, you see, it's just one little more short one. Now, so as long as that percentage of the remaining population is not zero in our pluralistic society, it will have never been zero. This is the very racial stereotype in the 14th Amendment forbids. And this is the argument, obviously, against the keeping the Section 2 of the 1965 Voter Rights Act, because maybe while in the beginning it made sense, it's one of those, along with the other part that's already been stripped, Section 5, I think it was, that required the states on the point systems, was the fact that it should have been sunset over time. Like back in the 60s when you had a whole lot more racism and everything like that, and racial issues with voting issues and all that, then this was needed. But now it's literally the point where you're forcing, like, I know when we did our redistricting map here in Texas, they created one or two new majority minority districts for blacks and one for Hispanics. Now, of course, Democrats are saying, oh, if these are declared unconstitutional and everything goes back to just regular districts, oh, that's going to lose 19 or 20 congressional seats to Republicans because all of those districts would go Republican. Well, no, because if there's a large majority of the blacks and they are all voting Democrat, then they shouldn't go all Republican. I mean, literally, they're making their argument for us. But yeah, you can go ahead and if you want to go ahead and talk. I'm sorry, I was done reading that, but
No, that was definitely a longer quote. Yeah,
well, I mean, I was taken from the amicus brief, and it was just literally section 1 of like 2 sections. It was under the it was race-based redistricting impermissibly uses race as a stereotype and a negative, section 1. Like, I didn't put section 2 in there. Section 2 is like section 1 and 2 is like 4 pages. So I just read section 1.
Yeah, it's interesting because, I mean, I don't know are you familiar with the term protected class at all?
Yeah.
In constitutional law, so race would be a protected class. But then there's also, I just thinking about this is what the only criteria for someone to be categorized as black, right, is whether or not they self-identify as black. So I don't know that there's actually a any kind of legal definition for the different races, right? Like that's not codified in law at all, right? Am I incorrect in saying that?
No, it's not that I've noticed.
So really, when you see this playing out in court, it really is just a proxy for who should have political power. And to think that that should be done along racial lines, I think that is the antithesis of kind of the direction the country was moving, which was race didn't matter. And I think by putting it on that pedestal, then we're kind of retreating back into, they talk about systematic oppression, but that's directly altering the system to prefer certain people and obviously disadvantage others. So,
well, yeah, and I mean that's pretty much what they're saying here is that what they're saying is literally that the only way for blacks, section 2 is pretty much saying only way for blacks or minorities, period, blacks, Hispanics, or whatever, the only that that they all vote Democrat. So the only way in a majority Republican states for their Democratic votes to count is for them to be in their own districts, which is racist in itself because you say that we can't draw districts based on race, but you're literally telling us to make a majority district based on race. I mean, that's literally what Section 2 is doing.
Yeah.
And the problem is maybe back when that law was brokered, yes, the majority of all blacks voted one way, but when you look at this last election, look how many blacks and Hispanics and young started coming over to Trump, started voting for Republicans. And to say that, and also the other argument is in there, which I didn't read the section that talks about this, is saying that it's also so they can have a minority candidate. But yet you have a black conservative Congress member in Texas who had to literally win in a Republican white district, and he won. So to say that, and obviously there's blacks in that district, but it was a majority white Christian district. Obviously I don't know, I can't remember exactly what districts he's in, so I don't know the actual makeup of white to black in his district, but it's mainly white. And yet he still won as a black candidate. So this argument that argument kind of goes to kill, because even what's his name in South Carolina, the other black conservative Congress member that's a big Trump supporter. I can't think of his name right now, but obviously that he won a majority white district too.
Yeah, I don't know who that is. What was it? That was South Carolina.
Yeah, I think
Carolina Congressman Joe Wilson.
Maybe it was a senator.
Ralph Norman.
Tim Scott. Yeah, Tim Scott.
That's
what I was trying to think of. Tim Scott. And you're talking about in a state that's majority. You're talking about winning a state that's majority white, and he's a black congressman.
Oh, so, yeah, Tim Scott. Yeah.
Yeah, so you got Tim Scott, and then you have the black congressman in Texas. He's up nearby Dallas.
I should know who that is, being from Texas, but I can't remember.
Wesley Hunt. That's right. I was trying to think of his name because he was just on Will Cain's show the other day, and another Fox News channel the other night. I couldn't think of his name, but yeah, Wesley Hunt, 38th district. So both of them right there have won. They're minority candidates who won in majority white districts and conservative at that. So this argument that, oh, we need this for that is ridiculous. And I would love to go. I'm going to see if I can get through it on here where it talks about, I got to look through my cases, but I was trying to think of where, like, what Justice Keontae Jackson Brown said today was just ridiculous. I mean, she had pretty much instead said that blacks are disabled, so they need a black only voting district. I mean, it's ridiculous.
Yeah, I think also adding to that list of people, Vivek Ramaswamy, right? He's running in Ohio. He's running in Ohio.
And you're not going to create a majority minority Indian district anywhere in the United States.
Exactly. And I don't think that there's any representatives of the Indian community who are calling for a special class,
voting district.
Yeah, exactly, for Indians. That would be crazy.
Because, I mean, yeah, you can do minority. You can do my majority minority districts in Texas for Hispanic and black. You can do blacks, and you can do majority minority black districts in Alabama, Georgia, Arkansas, Louisiana, which this one obviously is Louisiana, Calais, maybe Tennessee, maybe not. South Carolina, North Carolina, yes, but it'd be kind of hard because they're such small states.
But why race? Why not have they like? Where do they go? Go ahead.
Yeah, go ahead. Sorry, I'll finish.
I was gonna say why race? It's like, do they also need to draw districts around? Oh, this is XYZ number of trans people, gay people. You know what I mean? Like,
Yeah.
It's just focusing on race as like the sole, or Christians, right? Like evangelicals, like get XYZ amount of represent. I'm sure they'd actually like to do that, because I'm sure that would probably decrease evangelical representation. But
Yeah, it says, okay, so in a vacuum, this theory suggests Section 2 will take care of itself throughout the entire country, but that is where everyone gives the game away. Where do residential segregation and racially polarized voting remain high? Only in what they call the Black Belt of the Deep South, comprising portions of Alabama, Arkansas, Georgia, Louisiana, Mississippi, and South Carolina, which Mississippi was the only state that I forgot to mention. ID Section 2's proponents thus freely admit that it has real teeth just in places like the Deep South, where minority voters are still residentially concentrated and voting is still highly racially polarized. And no one knows when, if ever, that fact will change. If it never does, and perhaps it never will, Section 2 will never sunset in the South, is what it's saying. This is somebody's argument of why Section 2 should work. But in that way, moreover, this self-sunset theory is a de facto version of equal sovereignty problem that this court criticized in Shelby County v. Holder, which I know that one. This is the argument that's going for it. It's going for the Robinson. Race-based redistricting under Section 2 is not a compelling interest. The foreign grounds for affirmance are significant because they stand outside the strict scrutiny framework, is what they're saying.
yeah.
It is deeply important in Louisiana respectful view because affirming on those grounds would shut down arguments in future cases that race did not predominate in a particular map, and thus strict scrutiny is inapplicable, and thus courts and parties can sidestep the court's ruling in this case. I mean, it's crazy, but yeah, it's just Chief Justice Roberts, counsel, you began with Allen against Milligan. That case, of course, took the existing precedent as a given and considered Alabama's application of its approach to the evidence, and all that under that precedent. Is that your understanding as well? This is the actual case reading all the questions and arguments from today. I was trying to figure out I was trying to find where they speak in here today about their the judge's actual replies, and where they're actually making their statements in here.
I was Googling it, and it seems like it's not even done yet. It seems like
I have it right now. I'll pull it up, and let me get the.
What was it?
I did share it on this one. So there we go. And let me clear out this AI assistant. But yeah, so this is the actual from the day.
Oh, nice.
Yeah, so this is all the arguments from the day starting out. Yeah, this is 10:04 a.m. printed out from 10:04 a.m. this morning. Well, I mean, it's printed out this evening, but because I pulled this directly off the Supreme Court's website.
Nice.
So that's what I was trying to do, is go through here and see where her argument.
I don't think there's any way. I don't think there's any way the conservative Supreme Court is going to support the redistricting.
Well, yeah, and even it was even well, because even it's going to be a 6-3. It's going to be a 6-5. It's going to be a 6-3 or 5-4. But I mean, even Justice Clarence Thomas agrees that has argued against having the having them divided by race.
Yeah,
and all that. Even he said that it literally goes to the argument that they made, and that's why they mentioned in one part it was going to the case of the argument they made against affirmative action, and that was kind of the part that I read in the let me go that was kind of in this one that I read out of the amicus brief, and I was reading the amicus brief up here on the top. It was referring back to lacks a logical endpoint. And then it was when I was up here. Yeah, redistrict impermissibly uses race as a stereotype and a negative. So the thing I was reading up here was pretty much that whole thing. It says also inherent in this race-based redistricting system is the improper use of race as a negative. In zero-sum contexts like this, benefit provided to some, but not to others, necessarily advantages of the former group at the expense of the latter. Which this is going to kind of what you were talking about. The blacks benefit from this. What about the Hispanics? What about Indians? What about Asians? What about Middle Easterns? What about all the other minorities in the United States? And that's what this amicus brief, the kind of the creating a safe district for a minority group with allegedly shared political preferences comes at the expense of voters of other races who may have different political preferences.
Yeah, it's pretty common sense.
Indeed.
Right?
Yeah, indeed, that is the avowed purpose of race-based redistricting under Section 2. To its credit, on top side, amicus brief owns up to this elementary arithmetic. If an enacted map artificially restricts electoral opportunities for black voters, it says then the remedial map must provide additional electoral opportunities for black voters. The deficit cannot be negated without an offsetting sum. The same elementary arithmetic shows the effect of non-minority votes amid an effort to draw a majority-minority district. A surplus of non-minorities cannot be negated without an offsetting reduction. I mean, it pretty much says there's not really a way to do it. I mean, it's near impossible to really do or try to get to what they're talking about. And there's not really a way to get to that point without some other race or some other person being denied their rights. So,
and yet, if the Supreme Court were controlled by the left, they would justify it. You know, you know that they would, and it's one of those things where they will adopt any argument they need to in order to win more political power.
I wouldn't really say it's right versus left. Really, the difference it's originalism versus living constitutionalism. And originalists believe that really what they're doing is they're taking back the government back to the way it should be and restricting the Supreme Court and the judicial's the judicial branch's restrictions back to where they were supposed to be, and not allowing them to quasi legislate and saying, hey, that is constitutionally given to Congress and to the executive branch. Just because they don't want to act because they're too deadlocked or they're too ignorant to and they can't just come to an agreement or compromise or debate, it's not our spot to go in and quasi legislate from a ruling at the bench on a case to try to make some new law that's not even in the law that was written.
Well, do you remember Ruth Bader Ginsburg?
Yeah, I remember her.
So, did you know that she, on like 3 or 4 occasions, adopted an originalist, like using originalism as the basis of her decision, which flies in the face of what she advocated against, or for during her entire career. But then when she needed to basically win for her political side, then she adopted it. So
yeah.
And then Scalia honestly did the same thing in the opposite direction, with like the Citigroup ruling. But no, yeah, it's kind of I don't know if you've looked into like the concept of rule of law, but one of the concepts is that the courts are supposed to be in this esteemed position where they're trusted and they have a degree of separation from the influence of the
politics, which is
current political environment, as well as
which is
yeah.
That's why they have a lifelong appointment. That's why you can't force them to be removed. That's why it takes a lot to impeach them, even whether you believe somebody should be impeached for a move they make or not. That even if it's based on a political belief, that's why they do it. And that's why sometimes I'll say, man, that judge should be impeached. And they'll be like, and make some comment. I'm like, hey, I can make a political opinion comment that I want, even if I do have a doctorate of law and I know it's not going to happen. Doesn't mean I can't say I would like it to happen. I mean, that's just that's the freedom of being an American. I can
Well,
say I wish that would happen, but doesn't mean it's going to.
one of the side effects you get too when the judiciary is quasi legislating is that people lose faith, right, in the overall justice system and our judges and kind of the rule of law. So when that really destroys the foundation of a functioning society, and the logical outcome of that is political violence, which I think we're seeing today. And people have far less institutional trust in the Supreme Court today on both sides, right? Um, than even like 20 years ago. And if you go back 100 years, it's probably night and day, right? I mean, just
Yeah.
I mean, people have been targeting Supreme Court justices now with violence, right? Targeted violence. So it's hard to say how you step that back, though, right? I don't know how you step that back. Yeah.
And here, well, I know when they're talking about trying to fight, saying the other thing, Robert says, first and foremost, there is no precedent to suggest that a statute must dissolve on its own simply because it may require a race remedy. And as I've mentioned, race is not required by Section 2, but it can be used if that is necessary to address the Section 2 violation. Because the thing is, Section 2 is, if you really read it, it's just about voter dilution, period. It's not necessarily about race voter dilution. It's just about voter dilution. I mean, like you said, there's not even really a racial definition as far as what that to declare as what makes you one race or the other. I mean, you look if you saw my youngest one, obviously he could easily say he's black and everybody would agree with it. But my middle one, he looks more like his dad's side, and even though he's 3/4 or half black, you can't tell he is. Like, he looks white. He looks like he's my kid because he looks more like his dad's side than he does his mom's. And so, yeah, it's like he can claim he's black if he wants to because his DNA says he is, but everybody would kind of look at him like, huh?
Yeah, I mean, we already have with Native Americans where certain tribes have such a convoluted process of proving whether or not they're actually that tribe, and um, you know, part of that system is to make sure that they can concentrate the wealth in the hands of a few people from those tribes. So it's like imagining a government where now they have to have some sort of body and apparatus to judge and define each person, like, race by race, like, oh, you're XYZ% black, maybe you're black, like, yeah, could you imagine, like, it should it, actually putting it into practice would be very, very dystopian. And if you thought, the addition of DEI offices was bad and bureaucratic bloat, then I just can't imagine how they would successfully create this system.
What I like is I think this is the argument from Louisiana side. It goes, what is not grounded in case law is the idea that an entire statute should somehow dissolve simply because race may be an element of the remedy. So, for example, this case has affirmed Title VII. It has affirmed Section 1982 of the Family Medical Leave Act and also Section 4E of the Voting Rights Act and Katzenbeck versus Morgan, and never has it suggested that any of those states should dissolve in and of themselves. It's going back. They're pulling in the Family Medical Leave Act and Section 4 to Section 2. Reverence them back. But yeah. It's crazy. I haven't had time to read through all this, but yeah, it's going through and talking about it.
What a Brown, I'm curious to see what she said. Oh, there you go, Justice.
Yeah, there's Jackson. So no, this person's
he actually had a coherent question there. I'll go to that.
Yeah, this is well, okay, so that's not Louisiana, that's the other side. Miss Nelson's with is the plaintiff side. It's
Yeah,
not the state side.
definitely not. Definitely not Louisiana. Okay, cats.
Well, I guess I need to go towards the end because I need to get off of need it to go from Miss Nelson to it's probably gonna be halfway through when Miss Nelson is out and switches to Louisiana because it's probably gonna be after lunchtime. Yeah, it's probably gonna be after lunchtime when it switches to and that's when we'll start getting some of the really incoherent comments from Jackson and all them.
Yeah.
'Cause right now it's the person supporting it. But okay, here we go. Yeah, on behalf of Appellate Louisiana. It goes, race-based redistricting is fundamentally contrary to our Constitution. It requires striking enough members of the majority race to sufficiently diminish their voting strength, and it requires drawing in enough members of a minority race to sufficiently augment their voting strength. Embedded within these express targets are racial stereotypes that this court has long criticized. They assume, for example, that a black voter, simply because he is black, must think like other black voters, share the same interests, and prefer the same political candidates. And this stereotype and system has no logical endpoint. We are 40 years removed from Gingles, and yet, according to my friends on the other side, nothing has changed in the voting and housing patterns in Louisiana that require race-based redistricting. These problems are part of why we never wanted to be here in the first place. They have placed states in impossible situations where the only sure demand is more racial discrimination for more decades. But I think if anything is clear in this court's dedication to eliminating all racial discrimination, it is that the Constitution does not tolerate the system of government mandated racial balancing. And so, Justice Thomas. So, start out with Chief Justice Thomas, Justice Kagan. This would be where we'd probably start seeing. Let's see what Kagan said. The law more specific identify proved racial discrimination by the state. That's the way in which race-based districting is coming in. It's coming in as a remedy for specific proved discrimination on the state's part. How could that possibly fall subject to the categorical rule that you're suggesting? He goes, Your Honor, I respectfully but firmly resist the premise that this comes to the court on a finding of specific discrimination by the state. I think if anything is clear about how Gingles plays out on the ground, it is that once you run the three preconditions and get the totality of the circumstances, it's anyone's guess what the alleged violation is. So I'm going to take it down to, I mean, Kagan's, she can be pretty, Sotomayor's can be pretty out there. Kagan, it just depends. She usually has Sotomayor and Kagan. I've read some stuff of theirs in cases I've had to review, and they can usually be pretty collegial on the other side. But I want to get down to Jackson because she seems to be the one that's gets very attacking and not being very collegial about it.
Right.
Which is not the way a judge should be. Judge is supposed to keep filling in attacks and all that out of the courtroom.
Yeah, and they've said some terrible things about Thomas.
Yeah, they're not supposed to be doing that. They're supposed to disagree and debate, but not to that point. Kavanaugh will be good, but I guess, well, she's the baby in there, so she should go last. I mean, she is the newest member, so technically, I guess she should be at the end. Because they usually go in the order of the judges.
Wow, I never knew that.
Well, and like usually the youngest person is the one that writes the court's opinion too, even though it may not be in her own words, but she's usually the one that has to actually write the official opinion.
But she hasn't been.
Oh, Justice Jackson, I think there's a reason why this court's voting precedents go all the way back to Shaw. I are so tied up with race. It's because the remedy, as parties in the courts have understood Section 2 to operate, is almost always going to be race-based. That's why they went. No, they're so tied up with race because that's the initial problem, right? That's the beginning. The beginning is the claim that a person makes under Section 2 that because of their race, they are not being afforded equal electoral opportunity. It is a separate question as to how we go about remedying that and the extent to which we need to use race as a remedy. 2 issue is just that circumstance. Do we look at the determine which the problem of being electoral college? Hey, wait, so I can just ask, so why is that not a compelling state interest to identify areas in which that problem is occurring? Your Honor, of course, as this court recognized in SFFA, states can remedy intentional discrimination if they tell them about the remedy I'm talking about they can identify, all right, of course. So if I'm right that Section 2 is about identifying the problem and then requiring some remedy, I don't understand why you answer to Justice Kagan's question about this as a compelling state interest is no. The answer is obviously yes. And then you go too far and your remedy is about another issue. Your Honor, I think step 0 in all of these cases is what certainly step 0 in the Robinson litigation is the plaintiffs came in and said, we want another majority black district. I thought they came in and said, we are not receiving equal electoral opportunity because of our votes are being diluted, which is the same way of saying we deserve a second majority black district. No, it's not, because that, again, just trust me on this, the second electoral or second district is a remedy that one could offer for a problem that we identified. Still trying to figure out where she said in here that where she says about she goes, why do you need intentional discrimination? Really? Why do you need intentional discrimination? Because for a law to our Constitution, it's got to be intentional. You can't punish somebody because they unintentionally did something.
So it sets the standard of compelling interest.
Yeah. Right. Yep, and that's what he says. He goes, because if you're going to use race the way that the Robinson appellants want the court to use race and draw on a second majority minority interest, you've got to have a compelling interest. Well, she didn't say of Edward D. Green on behalf of the appellees. So, yeah, so that goes. But, I mean, yeah, it's over 176 pages, so I'll get that one. But now I'll go on to the second case, I guess, since we were only 39 minutes in. The second case I was going to go to is, let me get my other parts set up. Was Little v. Hickox or whatever it is. So now this case is a case that was filed in Idaho, where Idaho had made a law stating that transgender boys could not play in girls' sports, could not be in girls' bathrooms, locker rooms, anything like that. So obviously, Lindsay, as he calls himself now, Hickox, filed a case to say that was unconstitutional. The 9th District awarded in that way. Now it's gone to the, I think the state won on appeal or lost on appeal. So now they've appealed it to the Supreme Court. Obviously, now that it looks like with the conservative Supreme Court, Hickox felt like she was going to lose. So they tried to request the federal district court judge to remove the appeal and not rescind the case, which luckily the judge said no, the state is allowed to have their day in court. So then going to the amicus brief is it says that the fact under Title VII, sex plays an unmistakable role in the termination of a transgender employee. Bostock 590 U.S. at 660 sheds little, if any, light on either unlawful sex discrimination under Title IX or the constitutionality of state statutes under the 14th Amendment. Bostock's text-driven analysis centered exclusively on Title VII and the efforts of the Fourth and Ninth Circuits to impose its holding onto Title IX and the Equal Protection Clause simply to try to force a square peg into a round hole. This court made clear in Bostock that besides Title VII, no other law prohibiting sex discrimination was before it, and expressly declined to prejudge whether Bostock would sweep beyond Title VII to affect such other laws as Title IX. The only question before us is whether an employer who fires someone simply for being homosexual or transgender has discharged or otherwise discriminated against that individual because of such individual's sex. That goes back to what Bostock's question was. The court further clarified that even in the Title VII context, Bostock did not purport to address bathrooms, locker rooms, or any else of the kind. Given that locker rooms exist to facilitate athletic activity, the extensions of Bostock to strike down the women's athletic statutes under Title IX should have been a non-starter. To the Fourth and Ninth Circuits, now notwithstanding, numerous courts have accepted Bostock's disclaimer. So that's what it's going back to, and I think that's why they try to withdraw it. Is that's pretty much the Supreme Court's going to rule in favor of the Idaho law, saying that it is constitutional because Title IX is to protect women, not men who think they're women or identify as a woman. It is to actually protect biologically born women. And so now Texas, all other 49 states will be able to use the precedent set in this case to form legislation to enact the same laws. So this will be a major loss for the LGBTQI plus community and a major win for the people fighting against the ridiculousness of the transgender movement. Like I saw a thing yesterday was showing that less than 5% of the population are transgender. I mean, why should 95% of the country have to change because of 5% of the population?
I think it's 1%. I've heard 1%.
Yeah, it's below 5%. I mean, I think they were saying 5% of new college students claiming as transgender, under 5% now.
That's probably true. Amongst college kids, it's probably grossly exaggerated, I would imagine.
Yeah, and now obviously, like we talked about in previous episodes that we've done, I understand the point of the gay and bi community because that's closer to 30% of the population. That's almost closer to half of the population. That's a totally different story. But when you're coming to the transgender side, it's less than, I mean, they don't even have enough people to make their own sports teams.
Yeah.
If they had enough to make their own sports teams, they could have their own sports teams, but they don't have enough people to even do that. And to sit there and force our children to have to learn this stuff or try to tell them that they can be 36 different genders of they can be a unicorn and a purple bunny or something when they're little kids and they're already confused enough about who they are or what they want to be or who they want to be. Cause I know that who I am now and what I want to do with my life going forward now is nothing what I wanted to do when I was when I was in my 20s, much less when I was in my teens.
Yeah.
I mean,
I can't imagine having been exposed to that as a teenager.
And still the other problem is we still do not know or understand the health effects of stopping somebody from going through puberty when literally male genetics states that, I mean, just think of when women don't have estrogen, they're more prone to heart issues. They're more prone to overweight. They're more prone to osteoporosis and other types of bone degeneration. Same thing with men. When men are lacking testosterone, they're more likely to have muscle wasting and sleep problems and heart problems and a bunch of other stuff. And it's like you're literally trying to stop this person from ever creating when they're a baby. We don't even understand the long-term effects of what kind of long-term medical problems that can have, not including that so far most of the studies have proven that psychologically the people who have transition younger are no psychologically in a better position mentally than the people who transition when they're older. Some of them are actually in a worse of a psychological position because they got older and realized it's not what they wanted, but now the probability of converting back or ever being able to have children or reproduce or anything like that is slim to none.
Can't imagine.
Yeah,
Honestly.
and it's just I don't get it. It's so
Yeah.
I'm glad this state this I was trying to get the whole uh like the whole calendar pulled up to see what other major cases coming on there. I mean, the main thing is everybody's talking about the section 2 because obviously they think that somehow that's going to just eliminate a bunch of like up to 19 Republican Democratic districts because if it's ruled that majority minority districts are unconstitutional, then every Republican state would have to go back and wipe, including Texas, would have to go wipe out the two majority minority district. Well, actually, three majority minority districts they just created: one Hispanic and two black.
Yeah, that might blow up in their face. Who knows? I
And
think
then
that
so that
I think that the even now, the Supreme Court has been somewhat hesitant to push through extremely far right ideological, um, you know, rulings because I
yeah, but
think
I
a
don't
lot.
call this far right. I mean, saying that everybody should be treated equally and that race should not be included in the should not be a should not be a reason to be forced to do something that's literally creating a district that's only black voters in it. I mean, or a
No,
majority black voters in it. That's
I agree with
then
you. I
then
agree
because
with
then
you.
any of the white people that live in that district are now their votes are being wiped out. And I know that's one kind of the person was making an argument. The person for Louisiana at the beginning of the case when I was reading it was making the argument of is when you create a majority minority district of one minority, then everybody else in that district becomes the minority, and their votes become their votes get diluted.
Yeah,
So pretty much saying that there's no way to make sure that everybody's vote counts the same way if you're going to try to claim voter dilution based on race, not based on your the people's political ideologies. Like if you want to go voter dilution of drawing districts, then okay, if a district has a really big district that's all Republican, and then there's a large amount of Dem too much of a large amount, but still a minority of Democrats put in that district instead of another district that they would have not made Republican and made Democratic, that I can understand. That if we're gonna do voter dilution in section 2, it shouldn't be to race, it should be to registered political leanings or voting registration.
yeah.
It
You made
should
it.
be it should the map line voter dilution map line drawing should be based off of the actual based that way versus being based off of anything else.
Yeah, and I think they are gonna. I'm not saying like that would be a far right decision, but I do think back to COVID, right? Where even the right side of the court was making decisions that I felt were, you know, a little bit too, I guess, embracing of, you know, um, it's distracting me. Sorry, the devil video of myself is distracting me. The yeah, uh, shoot, I lost my train of thought there after I saw that video. Um, yeah, COVID. So yeah, when they were making rulings that I felt were not in favor of really what they should be doing, which is sticking to the Constitution. So I think after what was the big abortion case again? I can't remember the name.
Talking about you're talking about when they overturned Roe v. Wade?
Yeah, what was that? Shoot. Yeah, what was the name of that case?
Roe v. Wade, or you talking about the other one? I
Yeah,
can't think of I can't think of it off the top of my
I
head
would
right
normally
now
be able to
either.
tell you the name off the top of my head, but I can't think of it right now. But yeah, that
Let
that
me
I think after that decision where there was so much political blowback against them directly, I fear that at times they may not be willing to 100% stick with what they should be sticking with And I think a couple of their cases, a couple of the rulings they've made against Trump, I think that's a good. Those are good examples of, you know,
And I'm trying to see if I should have that case. I know I have I have that case in one of my files. I'm trying to see if I can find it. To remember the name, because I did a paper over it. I just can't remember what the name of the case was that overturned Roe v. Wade.
Dobbs v. Jackson.
Yeah, Dobbs. That's right, Dobbs decision. That's what I was trying to.
Yeah. I don't know why I couldn't remember that.
Well, I can't remember because I've done 100 other cases since then. I just trying to remember that exact decision. Like, I mean, I think just today I've read. I mean, you got Bostock, Miller. I read the name of like 5 or 6 different cases just since we started this. Just since we started this session. So I haven't really spoke about the Dobbs decision in probably at least 6-7 months, or even looked at the Dobbs decision in 6-7 months, because it hasn't really what's been on the what's kind of everybody's been talking about. So yeah, I mean that's
what law school's like, where you have a set of cases that you just use every day for 6 months and then you don't ever touch them again. You know, and then by the end of it, you have to know them again for the bar. So,
yeah. Well, luckily, I don't have to worry about taking the bar. I'm just since mine's on the administrative side, I don't have to worry about taking the bar. I mean, I could still go run to be a my doctorate in law and policy. Actually, by Texas law, it gives me enough legal and law and government law and policy courses to run as a what you would call it, where you marry and
magistrate,
justice of the peace. Yeah, magistrate or justice of the peace. Yeah, I think it's magistrate in the East Coast. It's JP in Texas. Like in the South and the Southwest, it's like JP, and in other states, it's magistrate. It just kind of depends on where you live to what they call it.
Yeah.
But like there, Matt, and what's funny thing is I remember I see. Well, this kind of going off our topic is still dealing with court cases and stuff, but it's going off of the Supreme Court cases. Is in the Comey thing. Comey's trying to challenge his case due to the fact that the assistant district attorney that President Trump appointed is not qualified because she's not a former attorney or nothing. But the thing is, in the Constitution, nowhere does it say that you have to be a licensed attorney or a former practicing attorney to be an attorney general, an assistant DA, attorney general, or district attorney, or even to be a Supreme Court justice. It's not a requirement. Now, most people who have been appointed to the Supreme Court or appointed as attorney general or appointed as assistant DA or assistant attorney general have formerly practiced as a lawyer or have been an attorney in a previous district attorney or something, but it's not a requirement. Now, at the federal level. Now, state levels, every state has its own rules. I mean, technically, I could run for a criminal judge, and I don't need to have practiced law. Now, in the state of Texas, they have our state constitution says that to be a criminal judge, you need to have practiced law for at least 10 years. But that's a state constitution rule. That's not a federal level. Federal law doesn't state any requirements other than age.
Yeah, and the idea that even how one becomes a lawyer, like the certification process, none of this is actually constitutional. There's no American bar association. Like at the time of the founding of the country, you could study law as an apprentice, and then today you have 3 or 4 different regulating bodies that serve as a gatekeeper. But I mean, we know that like under the foundations of our justice system, people themselves are supposed to have access to either lawyers or the rights to defend themselves. It should be accessible. But our entire legal system kind of
is set up to where it's gotten more set up to the way England was, where it's more limited to the amount of people that can get it. And the funny thing is also the fact is, like, Texas, honestly, I probably would have gone for my doctorate and done it through my JD, but Texas is one of the states still that does not allow you to do online courses for a bar. you can't do an online degree and still get your bar, which the funny thing is whether you're doing online courses or not, you're still going to have to research the case law. You're still going to have to read all the same stuff to be able to pass the bar, to be able to make the classes. So what should it matter if you actually did it in person or if you did it? I mean, now the only thing that's going to hurt you from doing it online versus doing it in classes, but I mean, even these days, you could do a lot of stuff through online. You could argue a court case or do a mock trial through like I'm doing right now, staring at a camera, talking to a judge on the other side. I mean, you could do mock trials through virtual now, because I mean, there are cases where they only been bringing the person to the court. They bring them in virtually through their attorney might show up, or their attorney will be at the jailhouse with them, and then they do it virtually to the judge. I mean,
Yeah.
so it's one of those things where, yeah, I mean, it's like the bar license doesn't mean that doesn't make you a good attorney. That doesn't make you a good lawyer. It doesn't mean that you truly know the law or that you truly know understand the concept of the law or understand how to interpret the Constitution, because that comes to actually understanding the words and having understand you're doing the proper research. And then really lawyering is less about knowing that and more how to convince people. Like you said, like we were talking about our last episode about politics and everything, is about telling a story. The better the story you tell, the more chance you have of winning.
Yeah. It's narrative building.
Yep. It's all about having the better narrative, being able to create that any shadow of a doubt. If you can create doubt, especially if you're protecting somebody that's facing trial for murder or any type of major criminal violation, doesn't even have to be murder, it just has to be criminal. All you have to create is some type of doubt to get them to either get a hung jury or get a not guilty. Because if they're not 100% sure that person committed the crime, then they're not supposed to, they can't return. Now, obviously, it can also be up to the judge how the judge words their directions or their instructions to the jury. The judge could leave it broad enough to where no matter what you do, they're going to come back with a guilty verdict. So sometimes it's more on the judge than it is the attorney there. It can fall really back on the judge too. But I guess you lost or fell off there. 6-7. I don't even know what 6-7 is, but I guess I lost my co-host here. So, well, we've already been almost on an hour anyways. So I guess I'll just go ahead and get ready to end it. I didn't see him putting chat message in there. Let me see if he got kicked out or lost it or something. And then, okay. Oh. So I don't know if on this live, am I 6-7 or what 6-7 on this live? I don't get the 6-7 thing. As that's, I don't do, this live, we were talking about court cases, and we started out with, I said 6-7 on what? I don't remember saying 6-7 on anything, but okay. I was talking about court cases, law. We started out talking about the Section 2 of the Voting Rights Act of 1965, and then we went and talked about the Little v. Hecox case that has to deal with Idaho law that made it illegal for transgender boys to be in girls' sports or bathrooms or locker rooms, and that case is now going to the Supreme Court to be heard. And then we got done with both of those cases, so we mentioned the Comey issue with the Attorney General and stuff, and that's what we were talking about when no, it's but anyway, so we're about over anyway. I've been here for an hour. And it's usually how long I do the episodes, for an hour. So since I lost my co-host there, thank you for everybody that was watching. If you're on here, please hit that follow, like, share button, and we'll be on here again next Wednesday at around 5:30 Central, 6:30 Eastern on TikTok. I mean, not TikTok, YouTube, Rumble, Twitch, Facebook, and X. So please check out where did my page go to? Okay, let me go. Please check out the website. Going across the little banner down there, it's No Kings on the Hill with drhilllaw.com. And you can catch all of our previous episodes. It was formerly Patriots Corner, but changed the episode name, just rebranded. So if you've been on, if you were looking for Patriots Corner, this is formerly Patriots Corner. And then I will see y'all next Wednesday. And